And then we can get started with our event. Welcome and good morning, good afternoon, and good evening to our guests, to our Democrats Abroad members, and to all of you who have joined in from around the world for our North Carolina State Supreme Court Meet the Candidate event hosted by North Carolinians Abroad. I'm Jennifer von Estorff, the Democrats Abroad Global State Teams Coordinator. And for those of you who aren't familiar with us, Democrats Abroad is the largest organization of US citizens outside the United States, and we're also an official arm of the Democratic Party. It's our mission to provide Americans abroad a voice in our government, and especially to elect Democratic candidates by mobilizing the overseas vote. In 2020, in no small part to the overseas votes, we were able to be the margin of victory in the tightest of races, including for Biden in both Arizona and Georgia. We are so grateful for everyone who voted in 2020, and we hope to be able to turn out even more voters in this crucial midterm election year. We must show up again in 2022 and find even more overseas voters than ever before. The very fabric of our democracy depends on it. And if you haven't done so yet, please go to the North Carolina Overseas Voting Portal and request your ballot, and encourage all of your overseas friends and family to do the same. Remember that overseas voters must request their ballots each election year, so get set now for May and November. At present, there are approximately 33,000 North Carolinians registered as overseas voters. We need to not only make sure that those voters show up, but that we grow this base. Who else do you know? Who else can you help to vote from abroad? Who can you share today's recording with to ensure that they vote this year? As we approach this critical midterm at Democrats Abroad, we're really looking to bring the elections and the issues closer to you so that you know who and what is on the ballot, and so that lawmakers stateside know about issues unique to overseas voting. In this vein, I'd like to thank our North Carolina State team for organizing today's Meet the Candidate events. We also thank all of our caucuses for submitting questions. And of course, we thank you, our attendees, for taking time to learn about the importance of the state Supreme Court. Today's discussion will feature Justice Sam J. Ervin and Judge Lucy Inman, as well as our moderator, Justice Robin Hudson. Please note that Democrats Abroad has not endorsed any candidates and is committed to remaining neutral for the duration of the primary. Both candidates are running uncontested in the primary. We look forward to doing all we can from abroad to see the candidates get the support from our DA North Carolina members. After the primary, we will do all we can to support the North Carolina Dems as they fight to win down ballot races, flip the US Senate seat, and send more Democrats to the House. Thank you for joining today, to our three speakers, to our North Carolinians Abroad team, and for all the work that went in to prepare today's event. And especially thank you to our caucuses for hosting: the Global Black Caucus, the Environmental and Climate Change Council, the Progressive Caucus, and the Global Women's Caucus. With that, I'll pass it off to Robert to introduce our first candidate. Thanks so much.
Thank you, Jennifer. My name is Robert Crane, and I'm a dual national, France and the United States. I come from Charlotte, North Carolina, and I now live in a small village in France about an hour from Bordeaux. Our North Carolina team came together in early January. Soon after starting the North Carolina team, I reached out to Alice Wardson, a high school and junior high school friend who opened many doors in North Carolina through her contacts as a former member of the North Carolina House of Representatives. Thanks to the hard work of Democrats Abroad North Carolina members Sylvia Squire and Mike Nitz, we moved forward quickly. And more recently, Tim Warmoth joined our team, having seen the first webinar. He helped and is helping the North Carolina team develop the Supreme Court webinar and brought Liz Fuller on board as well. They, along with Art Shankler, have helped to make today's webinar possible. And now I'll cede the floor to Sylvia. Sylvia?
Hi, I'm Sylvia. I too am a dual national, UK and US, and live in London now. But I had spent nearly 40 years in the States, moving from New York to North Carolina in 1993, and like Robert, to Charlotte, even though he was born there, I believe. Like many of you, I've been a member of Democrats Abroad for many years, but I did not become active until after the 2016 election. Our North Carolinians Abroad state team is committed to connecting with more North Carolina Abroad voters in 2022 than ever before in the midterm and beyond, to help elect the chosen candidate to the North Carolina Senate, elect candidates to the North Carolina Supreme Court, and to keep our Democrats' House seats. There is still much to do, so please join us. You can help by phone banking all our North Carolina voters, sending postcards, offering voter registration assistance, connecting with study abroad programs, going on or near military bases, reaching out to family and friends who live overseas, and so much more. And links will be posted in the chat through the course of the afternoon, evening, depending on where you're zooming in from. So Robert, let's go back to you to introduce Justice Sam Ervin and Judge Lucy Inman.
Thanks, Sylvia. Justice Sam J. Ervin IV graduated magna cum laude from Davidson College in 1978, where he majored in history and earned his law degree cum laude from Harvard Law School in 1981. Justice Ervin was elected to the North Carolina Court of Appeals in 2008 and served on the Court of Appeals until 2015 and was a member of the North Carolina Utilities Commission from 1999 until 2009. Justice Ervin was elected as an Associate Justice on the North Carolina Supreme Court on November 4th, 2014, winning a full term that expires on December the 31st, 2022. Since joining the Supreme Court, he's participated in deciding more than 540 cases and has authored more than 65 majority and 16 dissenting or concurring opinions. As a member of both the Court of Appeals and the Supreme Court, Justice Ervin earned a reputation for thoughtful legal decision-making. His opinions are perceived to be balanced, thorough, and reflect a careful study of the facts and a reasoned application of the law. Justice Lucy Inman graduated summa cum laude from North Carolina State University in 1984, where she majored in English. Her first career was as a newspaper reporter. While covering court proceedings, she was inspired to participate in the justice system and earned her law degree, magna cum laude, from the North Carolina School of Law in 1990. Her first job after law school was working as a law clerk for North Carolina Supreme Court Chief Justice Jim Exum. In 2010, Judge Inman was appointed by Governor Beverly Perdue to serve as a special Superior Court judge. She served in that role for 4 years, presiding in hearings and jury trials across North Carolina. Judge Inman was elected statewide as a judge on the North Carolina Court of Appeals in 2014 to an 8-year term expiring December 31st, 2022. She has authored more than 500 appellate opinions and participated in thousands of decisions, including criminal, civil, and constitutional matters. Her record shows that she consistently applies the law fairly and impartially, understanding that each decision affects people of all walks of life in communities as varied as North Carolina's 100 counties. Judge Inman is a candidate this year for an open seat on the North Carolina Supreme Court to succeed Justice Robin Hudson, who is not seeking re-election. Sylvia will now introduce Justice Robin Hudson.
Born in DeKalb County, Georgia, after studying philosophy and psychology at Yale University, Justice Robin Hudson earned a JD degree from the University of North Carolina at Chapel Hill in 1976. Except for 3 years as a state appellate defender, Justice Hudson worked in private practice in Raleigh and Durham, North Carolina, until 2000, when she was elected to the North Carolina Court of Appeals, the first woman to be elected to an appellate court in North Carolina without being appointed first. Justice Hudson, excuse me, was elected to the North Carolina Supreme Court seat of retiring Justice George Wainwright in November 2006 and took office in January of 2007. Justice Hudson was re-elected to the court in November 2014, and since 2015 has been co-chair of the Judicial Independence Committee of the National Association of Women Judges, which creates and presents materials to educate voters about judicial elections. Justice Hudson wrote the Supreme Court's 2022 opinion, striking down the state legislature's congressional and legislative districts as excessively partisan gerrymanders. As Robert said, Justice Hudson has chosen not to run for another term in 2022, as she would have reached the state's mandatory retirement age about 13 months into that term. Justice Hudson, I see you're already unmuted. Please go ahead and start the ball rolling for today's discussion. Thank you.
Thank you, Sylvia, for that introduction. And thanks to all of you for organizing this event and to all of you for attending, for taking the time to be here. Today we are talking about, and with two judges who are candidates for two different seats of the 7 on the North Carolina Supreme Court. These two seats are up for election in 2022, and you will be hearing conversation with these two in just a moment. But I just want to start by pointing out how very important these elections are for at least 3 reasons, and there are many others. First, the courts are one of the 3 branches of our constitutional democracy, and it is the one that's not intended to be political, but is intended as a check and balance on the other 2. In the oath that we take, we promise impartiality and to have no agenda. But like in 38 other states in the United States, judges in North Carolina are elected. So it's a tricky balance. Second, 90+% of everyone's interaction with any court in the US involves state courts. There are hundreds of millions of cases decided annually across the United States in civil and criminal cases all across the states. So they're very important. They touch everyone. And third, the issues that are dealt with by the state courts are the closest to you, the things that people care about the most, such as you heard, our votes, issues affecting our families, our property, your schools, and our safety. So all of these are very important reasons to pay attention to the elections for the courts. And so that's why we're here to help educate you and give you some information about these important races. First, I want to add, before we get into the discussion, a very important disclaimer. Since I'm not on the ballot, there are limitations in our code of conduct about what I can say in this context. Nothing that I say should be taken as an endorsement of any candidate or as taking a position on any issue that might appear before the court. I am specifically permitted to speak and encourage education of the public about the judiciary and how the court system works. So that's what we're doing. So we've asked some groups for some questions for our 2 candidates. And the first topic is on redistricting and gerrymandering and voter issues. The first question came from the Global Black Caucus, and I will start this one by giving it to Judge Inman. The question will be the same for both of you. How did the North Carolina Supreme Court approach let me change that. I'm going to give this to Justice Irvin first, since he was on the court when we did this. How did the North Carolina Supreme Court approach the issue of congressional district gerrymandering, and what was the decision?
Well, and I'm almost tempted to lateral it back to you because you actually wrote the opinion. I joined it, but you were the reigning expert on the subject rather than me. And I think to add at the very beginning, I want to add to your disclaimer a couple of other things, and this governs both Judge Inman and me. We are both sitting judges under the same code of judicial conduct that Justice Hudson alluded to. We are prohibited from expressing opinions about the merits of any case that's pending in the North Carolina court system or in the federal courts involving issues related to North Carolina. So we can talk about what the court has done. Our ability to predict what the court might do in the future is exceedingly limited. And I think both Judge Inman and I have been very careful about not doing that. But to describe what was done with respect to redistricting by the North Carolina Supreme Court, we have, as many of you know, had a decades-long history of very contentious redistricting litigation going back into the 1990s, when my father actually was a federal court judge and sat on some of those things. The issues up until relatively recent times have involved allegations of racial gerrymandering, which resulted in some invalidation of districts in the last redistricting cycle. In the present redistricting cycle, a lawsuit was brought in the state courts contending that the legislative and congressional districts that were adopted in North Carolina by the General Assembly were excessive partisan gerrymanders. in view of the fact that the U.S. Supreme Court has essentially decided it is not going to get involved with respect to such claims, that case was litigated in the state courts. It was referred to a 3-judge panel of trial court judges who made findings of fact that described the effect of these various the various districts that were created and analyzed them in terms of various statistical tests before holding in effect that the state courts, like the federal courts, didn't have the authority to consider these particular claims and dismiss them. The case came before the Supreme Court of North Carolina on an expedited appellate process, and we voted earlier this year by a 4-3 vote in an opinion that Justice Hudson wrote that the trial court's findings of fact, which showed, among other things, that if one did statistical analyses, they were 99.99% more favorable to one party than the other. We held that under 3 different provisions of the North Carolina Constitution, claims for excessive partisan gerrymandering were in fact cognizable by the courts, and held that based on the trial court's findings, we had such excessively partisan gerrymanders in this case. We then remanded it. We then gave the General Assembly a chance to redraw maps. They did so. Those maps were then referred back to the trial court. The trial court approved the state House and state Senate districts, decided that the congressional districts were still impermissible, substituted a set of maps that they drew for the congressional districts. We declined to set that decision aside, allowed elections to go forward. The United States Supreme Court did not intervene, although there is still a petition pending before the United States Supreme Court with respect to the congressional districts, which is why this case is one that Lucy and Robin and I can't talk about in any predictive sense. But the effect of that decision was to recognize a partisan gerrymandering claim under North Carolina law and to invalidate the districts for state House, state Senate, and the Congress that were adopted by the General Assembly last year.
Thank you. That was a very good summary. And it's very important to note that a significant basis for the striking down of the maps was the provisions of the North Carolina state constitution. And there's a link to the case in the chat. So Judge Inman, did you have anything to add to the summary of the gerrymandering decision, or anything that you would like to say about that?
I'll just add briefly. I would hardly add any substantive content, given that I don't serve on the Supreme Court right now. But I believe that the majority opinion, or the whole opinion, there's also a dissenting opinion, have been placed in the chat for you to see. And even regardless of whether or not you're a lawyer, if you read the opinion in this case, it meets some of my criteria for what shows justices doing their job correctly. Number one, it's written in a way that a high school student should be able to understand. It is quite lengthy, but if you read even the first 10 pages, you can get a preview of the analysis. The other thing that this opinion does is it does what my middle school math teacher told me to do. I was terrible at math, I'll admit it. And she would say, don't be clever and think you could just guess the answer. Because even if you get the right answer, if you don't show your work, I'm only going to give you half credit. And this opinion shows the work. It traces the history of the North Carolina Constitution and the provisions in the North Carolina Constitution that apply to recognize this extreme partisan gerrymandering claim. It cites many of the more than 600 findings of fact by the trial court that Justice Ervin mentioned. And it cites legal authority from the North Carolina Supreme Court, from the US Supreme Court, so that anyone reading this decision, whether they personally agree with the court's conclusion or not, understands how the court reached that decision. And if we can't, we must have that available to the public to have public confidence in our courts.
Thank you for that, Judge Inman. And again, none of us really know where it's going to go from here with other courts taking a look at it.
And I do
coming
think,
back.
and I do think we've alluded to the fact that that part of this case is pending before the U.S. Supreme Court. The legislative defendants have taken the position that the courts have no authority to redraw congressional districts under a provision of the federal Constitution. That issue has been bandied about for a number of years. I gather it goes back to Bush versus Gore, but it says in effect that even if there is some constitutional deficiency found in congressional districts, that only the state legislature has the authority to fix them, that courts do not. And we addressed that issue in the opinion that Justice Hudson wrote and reached a contrary conclusion, but that is a very live issue both in North Carolina and nationally at this point.
Definitely. So we're all keeping an eye on that, but I think we need to move to the next question. Thank you guys very much. The second topic is a question that we've gotten from the Global Women's Caucus. And this one will start with Judge Inman. It's kind of an open-ended question. What kinds of cases do the courts hear, especially the Supreme Court, about North Carolinians' access to healthcare, including reproductive healthcare?
Well, the North Carolina Supreme Court, like the Court of Appeals where I sit now, hears all sorts of cases about access to healthcare. We have comprehensive statutes in North Carolina about healthcare for people from birth until death. And I must reiterate what Justice Ervin said. I know that on everyone's mind, there are some particular issues about reproductive healthcare that are certainly on the horizon. I cannot express an opinion about those matters because if I did, someone would say that I would have to recuse myself from deciding any of these cases. And it's very, very important that I not ever lose the opportunity to decide one of these cases. But the North Carolina Constitution provides for, in general, I'll just say in general, the North Carolina Constitution provides for some rights that are not exactly as they are written in the federal Constitution, and for some rights that are not mentioned at all in the federal Constitution. Chief Justice Exum, who I clerked for at the North Carolina Supreme Court, was one of the earliest justices to really delve into our state constitution. Justice Hudson has done a lot of that herself as well. And I cannot predict anything except to tell you that having justices who are willing to do the hard work of looking carefully at our state constitution is very important to protecting all kinds of rights, including the access to health care. And that is because the federal Constitution is a floor. The federal Constitution recognizes fundamental rights that no one can take away from you, no matter how unpopular your right may be, no matter what raw political power other branches of government may be exercising, the federal Constitution protects your rights. The state constitution in North Carolina, like in other states, can never provide less, or if it did provide less protection to you, you would have protection under the federal Constitution. But the state constitution in North Carolina can provide greater protection than the federal Constitution. We have seen that in decisions from our Supreme Court on the issue of access to education. North Carolina's Constitution has been held by our Supreme Court to provide a fundamental right to a sound basic education. We've seen that in our Supreme Court in the right of every worker to the fruits of his labor. And we've seen that in regards to free and fair elections. At the Court of Appeals where I sit, and at the North Carolina Supreme Court where Justice Hudson and Justice Ervin sit, We've had many kinds of healthcare access cases. The cases that I have presided in have mostly been medical facilities and state regulations about the location of medical facilities. It's very much governed by statute and by regulation. And it is not my job at the Court of Appeals to change the law. It is my job to follow the law and to apply the law and to follow the precedent from our Supreme Court. That's really all I could say about that.
Thank you very much, Judge Inman. Justice Ervin, do you have anything to add to the question about access to healthcare and the kinds of cases that the courts address?
Not a lot. I think Lucy basically covered them. In thinking about what we were going to talk about today, I've made sort of a mental list of the kind of healthcare related cases that I recall having decided over the course of my judicial career, and they included the facilities cases that Judge Inman referred to. They refer to as certificates of need. The state has the right to decide whether a particular medical facility can buy or use a particular piece of equipment. It's a law that's rather controversial, but it's still on the books. And we hear those occasionally. We also hear, interestingly, a number of cases involving the appeals from denials of Medicaid or Medicare coverage, which are important, particularly to some of our low-income citizens. And we've had at least one case that I can remember about the funding for that program that was heard a number of years ago. We get a fair number of medical malpractice cases that's not directly related to access to healthcare, but they are healthcare related, and we continue to see those. And so we do get healthcare related cases on our agenda. As Judge Inman said, we can't really talk much more about what we might do in particular cases. I am aware, at least, that a case that seeks to persuade the courts to adopt Roe as a standard under the state constitution has been filed in the trial courts. It has not reached the appellate courts yet, and because that case is pending, and because there's some possibility that if I'm reelected, I might be called upon to sit upon it, I can't comment on it any further. But I did want to point out that at least my understanding that it's there.
That's good to know. And also, another area that we've seen in recent years is appeal of the procedures for involuntary commitment for evaluation of mental health. And we see those from time to time. There's a whole range of issues that touch on healthcare. But thank you for those answers, both of you. That was very helpful. Topic number 3 is very important, probably the heart of the matter today. And I will start with Justice Ervin on this one. This is a question from the North Carolina team. Given that the oath that we take as judges requires us to be impartial and not favor any side, how do you run for office with a party label on the ballot, but still attempt to appear non-political? And there's sort of 2 parts. That's the first part. How do you run a campaign? And have recent changes in the treatment of judicial elections altered your approach?
Well, the answer to the first question is pretty simple. It's hard. I don't know any other way to put it. I am not a believer in partisan judicial elections. We're one of the very few states that have moved from nonpartisan to partisan elections in recent years. I'm very concerned that certain measures that have been taken with respect to judicial elections are likely to have the effect, even if they're not intended to have the effect of further politicizing judicial elections, which is probably the last thing that we actually need. When I first ran for the Court of Appeals in 2008, and when I ran for the first time for the Supreme Court in 2012, and again when I was elected to the Supreme Court in 2014, these elections were nonpartisan in nature. We also had a public financing system that was repealed by the General Assembly effective 2013. It was in effect during some of these periods of time. And essentially all of us ran as on our own merits. We were not tied to political parties. We didn't run on a party ticket, although it would be a bit disingenuous to say that the parties didn't care. But we were not nominees of the parties and were not treated as such. This year, we are all running in a partisan election, so that Lucy and I filed as Democrats and are, by virtue of the fact that, as was said earlier, nobody filed against us in the Democratic primary. We are the nominees of the party in these 2 elections. But I think the real issue that we face in judicial elections in North Carolina this year is what kind of courts are we going to have? And I think it's fair to say that there are people in this state who very much would like to have courts reflect their political and ideological view of the way that the system ought to operate. I'm not going to say much more than that, but the fact that we've gone back to partisan elections, the fact that we've had large third-party expenditures in judicial elections in cases that I was involved in, and also in Justice Hudson's re-election campaign in 2014, in which a particularly ugly attack ad was running against her, shows that these forces are out there. And so the way I have tried to address the issue that's the bottom line for this question is to say, which I think is true, that the Democratic Party has taken a number of measures in recent decades to try to make judicial elections nonpartisan and less political. And I supported those measures, thought they were good policy, and wish they were still there. It was not the Democratic Party that changed the system so that it is what it is today. And that the Democratic Party and the judges that have been elected by the Democratic Party take the position that what we're supposed to do is decide individually each case based on a fair and impartial determination of what the facts are and what the law is, and on the basis of nothing else, and not to have any sort of ideological or political agenda. And that's what I think our records, I contend that our records show. And I think that's what people ought to want. Hopefully we will be able to persuade the voters that that's the case, but I think how these elections turn out is going to really determine what kind of court system we have in North Carolina going forward.
Thank you for that very much, Justice Ervin. And I just want to throw in that there was an ugly attack ad against me in 2014. The backlash was such from the public as well as the press that I won by the biggest margins ever, which I found reassuring. And my sense was that the public at some level understands that the judges are supposed to be impartial arbiters. But Judge Inman would love to toss this question to you as well. Again, given the oath, how do you run a campaign with a party label, but still appear non-political? And what, if anything, have recent changes in the process done to alter your approach?
Certainly. Well, the first time I ran statewide was in 2014 when I was on the ballot with Justice Hudson and Justice Ervin, and they were nonpartisan races. I had been a trial court judge for 4 years, and I am a lifelong Democrat. I referenced this morning, at least in North Carolina, the mission statement from the Democratic Party says that we are united by shared values that define who we are and what we stand for. And it says fighting to ensure all North Carolinians have a fair shot at a good life, regardless of their background, where they came from, their economic status, or who they love. Well, those are all values that I share, that Justice Ervin can say that he shares, but we cannot promise how we will vote in any individual case to deliver upon that mission. That's why we have a third branch of government. What's changed since 2014 is that the polarization has gotten sharper and sharper and sharper. Justice Hudson was attacked in 2014 with an ad that said that she was a friend to or soft on child predators. I don't know if we'll see ads like that again, but we've already seen one ad this year targeting Justice Ervin, and with reference to a specific case. And so I think it's getting more and more polarized. The thing about partisan judicial elections is that they create both a hope by extreme partisans in any party, right, that the judges are going to vote in a way that toes the party line, and they create fear in members of another party or unaffiliated voters that a judge isn't really going to fairly consider a case. And for partisans who just look for the R or the D on their ballot, partisan judicial elections may give them what they want, as Justice Irvin said, if they want to just have a judge that's going to promise to deliver on their party agenda. But for judges who are running on a nonpartisan platform, as we are, it really requires voters to know who the candidates are and to remember our names, because that's really all we can stand for. I have a cheesy statement here in North Carolina, which is look for Lucy, search for Sam, save our Supreme Court. And I want people to know our names, because our names and our records are really what we're running on. I don't think there's been any candidate elected to an appellate court in North Carolina who has not been affiliated with a political party. That's an infrastructure that allows us to connect with people across the state. I am so grateful that the Democratic Party understands the third branch of the government that we serve in really is different than the other branches, and recognizes that when judges are allowed to be independent and decide cases fairly and impartially without fear or favor, we all win.
Absolutely. Thank you for that, both of you. And it's especially important because that's what the oath that we take requires us to do. Whether voters or individuals expect judges to toe a party line, that's not what our job is. Our job is to decide cases impartially, and that requires education of the public, which is, as a result of the attack ads that ran against me in 2014, the National Association of Women Judges reached out to me to become involved in their national education effort of the public, which is has been going on for more than 10 years. And I'll come back to that at the very end and refer you to where you can get some of those materials if you want more information. But this is a very important matter in the states that have elections. And like I said, it's the last time I checked, it was 38 or 39 states in the United States that have some form of election of judges. So did you have a question, Judge Inman?
I just wanted to add that, yes, just within the last month, Ohio became the second state in 100 years to go from having nonpartisan appellate judicial elections to having partisan. And I read that this was following North Carolina's lead. And so that's just changed in Ohio.
But to emphasize one further point about this, if you look at the records that Judge Inman and I have developed, I mean, there's no question that that both of us were affiliated with the Democratic Party. I have been all my life. I was a county chair when I was in private practice many years ago. But both of us have made decisions in which people who were predicting what we were going to do based solely on the fact of our party affiliation might have been surprised to see. Because what we did was look at what the law is and reach the dispassionate conclusion as to what it required us to do, even though some of our political allies may not always be happy with that. I think that's what we're supposed to do. I think that's what we've done. We have not gotten out, unlike some folks that are running against us, and put political and ideological labels on ourselves, because I think both of us feel that it's really important that judges be what they're supposed to be and not something else.
Absolutely. I think that judges make decisions every day that may not be lined up with what the party or some of our friends would want. And that just tells everybody that we're doing our jobs. And that's what we're supposed to do. So thank you all both for that. That's a really important heart of the matter type of question. The fourth question is a different topic, a little shift. This is back to the kinds of cases that the courts decide. And I will start this one with Judge Inman. This one comes from the Environmental Climate Change Council. What kind of cases, if any, come before the courts that affect environmental policy?
Well, more and more cases are coming before the courts that affect environmental policy because parties, litigants, municipalities, citizens are more aware than ever of the natural resources that are just irreplaceable in our air and water and our earth. At the Court of Appeals, and at the Supreme Court. I don't think there are any cases that are exclusive to the Supreme Court about environmental policy per se, but we hear cases including lawsuits about pollution that's ongoing. And Justice Ervin can talk about the hog waste cases that he's participated in, that I have not sat on those cases, but these are cases by neighbors of hog farms or other industrial farms that have a lot of aggregated waste that is affecting the air around them. Another area that affects the environment, which is not about pollution directly, but North Carolina, like many states, has initiatives to try to reduce its reliance on carbon fuels, and that has led to great growth in the solar energy industry. But the North Carolina Utilities Commission, which is part of the executive branch, excuse me, pursuant to laws written by our legislature, has to issue permits, sort of like we were talking about for hospitals. They have to issue permits for energy generating facilities, and that includes solar facilities. Recently, the Court of Appeals heard, and I wrote an opinion in a case that was appealed by a solar facility entrepreneur who had been denied a permit from the Utilities Commission. And the reason the permit was denied was essentially that, and it reminds me sort of like the problem of increased traffic and highway design. The utility companies in North Carolina have an electric grid. And if you're providing energy to consumers, you have to plug into the utility company's grid, and then it will deliver it to consumers. Well, there's gridlock on the grid in southeastern North Carolina, where we have lots of flat land and lots of sunshine. You can't get, there's more energy than the grid can handle. And so that's an example of a case in which really it's going to take the other branches of government to work on that framework. And we affirmed the Utilities Commission in that case, and we did comment that we could see how frustrating this might be, but the court's role is again to follow the law, and we do comment. I do comment in opinions when something seems impractical, because I consider judges to be the truth tellers of government, and that's the most that we can do. Justice Ervin, I think, probably has more cases to talk about.
I think Justice Ervin, especially when you mentioned the Utilities Commission, his eyes light up.
Yes, I know they do.
Served there for a number of years, and we're all
Yes,
glad that he had that experience. So take it away, Justice Ervin.
I may be the only person who does not think that utility law is the functional equivalent of paint drying, but it is an area that I spent a lot of time in, both as a lawyer and as early in my career in public service. And so, yeah, I'm interested in it and happy to talk about it. We have a number of cases in front of the Supreme Court that have dealt with environmental issues. One of the ones that I'll mention first is that the court handed down a fairly, at least from my point of view, was a fairly significant decision that I wrote that was almost as long as the opinion that Justice Hudson wrote in the redistricting case, involving the Utilities Commission's decision with respect to how Duke Energy was entitled to recover the cost of compliance with various coal ash disposal statutes. And we ruled in effect that the commission was authorized to do some of what it had done, but it had failed to do so properly because it failed to explicitly consider the possibility that Duke might have engaged in environmental violations as the result in determining what amount to allow the customer's rates to be increased to reflect the cost of coal ash compliance. And we have another coal ash related case pending in front of us right now that obviously I can't talk about any further. The other environmental case that we've had that, we've had two iterations of so far. Back in the late 1990s, the then Attorney General Easley entered into an agreement with Smithfield Foods to as part of its issues and part of his effort to deal with issues involving hog waste in the eastern end of the state, in which Smithfield and some of its subsidiaries agreed to make a contribution of, I think it was $2 million a year, up to a total of, I think, 50, to fund environmental compliance efforts or remediation efforts. In the last several years, there's been an attempt to have that agreement invalidated under various theories. We've heard two different versions of that case and have ruled both times in favor of the Attorney General, so that the program is still intact, at least at this point, although there's likely to be, I don't know if it's likely, it's certainly possible that there'll be further litigation over it, so that we do hear some fairly directly environmentally related cases over time. And I suspect, as Judge Inman said, the amount of work that we do in that area is likely to grow.
Well, and from both of your answers, it should be clear to our audience that a lot of the cases involve looking at very complicated regulatory schemes. Instead of just a straight up, are you in favor or against some environmental policy? They tend to be very complicated analysis of the law. And another one that occurs to me that we heard that was argued not too long ago and has not yet been decided involved the authority of a homeowners association to control or prohibit placement of solar panels on a roof in a development. So that one hasn't been decided yet. So that's all I'm going to say about it. But that's a good sort of smattering of the range of issues that we see involving that kind of regulatory process. But thank you for those answers. That was really helpful. Topic 5 is again a sort of an open question, more open-ended. This one is from the Progressive Caucus. And I will start with Justice Ervin on this one. Could you give us some sense of the scope of your caseloads and how they affect the day-to-day lives of North Carolina citizens? And could you point to some of the most important issues in your view that the court has addressed?
But it would be hard to find an issue that we have not had litigation about at some point in the 7.5 years that I've been on the court. And Justice Hudson can probably add to the list that I'm going to give you because she's vastly more experienced than I am. But I mean, about half of our cases are criminal, about half of them are civil. On the criminal side, some of the more important cases that I think we have decided in recent years included, for example, North Carolina passed something back in about 15 years ago called the Racial Justice Act. The court a couple of years ago held that the General Assembly's subsequent attempt to repeal that statute and make the repeal effective as to people that had asserted claims under it was an unconstitutional violation of the state constitution. We've had a number of recent cases involving alleged racial discrimination in the selection of juries that have resulted in at least the invalidation of one conviction because of a finding of such discrimination in the case that Justice Hudson wrote. On the civil side, we hear all kinds of different things. We hear major business cases. We haven't talked about that much, but that's been an area that I've worked in a lot, dealing with security regulation, fraud-related questions, real estate questions, all sorts of things that only a true nerd like me could really love. And then we also hear, alluded to medical malpractice cases already. We've heard a number of we hear land use cases involving, Justice Judge Inman alluded to one of those in her discussion of the power grid a little bit ago. And then we've also heard a number of other cases that related to other state constitutional issues in my time. For example, I wrote an opinion a number of years ago that addressed change that the General Assembly made to the composition of the State Board of Elections that we struck down the statute as violating separation of powers. I wrote another opinion early in my term of service on the court invalidating the statute that the General Assembly passed that divested the city of Asheville of its water system as violating another provision of the state constitution. On the other hand, I wrote an opinion a number of years ago upholding the statute that the General Assembly passed that reallocated authority between the State Board of Education and the State Superintendent of Public Instruction. our cases cover the waterfront. It's hardly, I mean, everything we do has direct impact on some or all of the citizens of the state. I mean, it's hard to find something we do that doesn't have broad public impact.
That was very enlightening, Justice Ervin. Judge Inman, you probably have some to add.
I can add a little bit, and even if we had hours, I couldn't add enough because it really is so much. One area of law that affects families in North Carolina, well, two areas of law, it's just family relationships. And one is the custody of children and the care and custody of children. Trial courts in North Carolina hear claims every day, whether it's parent versus parent or the county social services versus parents, about the well-being of children and where they should live. And the Court of Appeals, where I serve, hears those cases in the first instance, and then the Supreme Court hears appeals from our court. There are cases involving the termination of parental rights, and that is when a trial court finds that a parent has acted so inconsistently with their duties and their rights as a parent that the parent can have no longer right to their children. And that's a constitutional issue in every single case. We've recently had a case that was decided in the trial court and then heard at the Court of Appeals and then affirmed at the Supreme Court about whether one member of a same-sex couple could obtain a domestic violence protective order from his or her partner. And this seems to me to be, and the case has been decided, I don't expect it to come up, and Justice Ervin and Justice Hudson can correct me, but I would just surmise that this is one of those situations where the forms don't always keep up with what the law is. And literally it was just a matter of whether a box could be checked or be filled in. And the Court of Appeals, in a divided opinion, and then the Supreme Court in the divided opinion, held that yes, you have a right to be free of domestic violence, whether or not your partner is of your sex or of another sex. Criminal cases, in terms of criminal cases often will overlap with mental health, such as the mental ability of a suspect to give permission for a search, where the police can go and interrogate somebody if they are in a hospital, all those kinds of issues. But it could be everything from driving while impaired to first-degree murder, and then those more abstract, I'll call them, cases. I've written a decision about the separation of powers between North Carolina's Board of Education and the legislature, and sometimes and between the legislature and the governor. As Justice Ervin alluded, there's a lot of policy that our legislature can pass that we might really think is terrible, but if it's not unconstitutional, we're not going to strike it down. But we're going to take a close look at every case that comes before us.
That's also very helpful. And as you both pointed out, it does really cover the entire range of issues that the law addresses in North Carolina. One that particularly comes to my mind, because I did this in law practice for 25 years, is workers' compensation. The litigation of matters when somebody gets hurt or sick as a result of conditions at work. And those go through the Industrial Commission, which is a state agency, and then go directly to the Court of Appeals and then to our court. And we usually have some of those cases going on. They're very important. There are hundreds of thousands of cases every year that affect what happens to people when they get sick or injured at work. And Jimmy, I think, mentioned covering the waterfront. We literally have cases about waterfront matters, access to beaches. We had a case involving long-running litigation over the status of Hammocks Beach and whether it could be a state park or whether it had to be in private hands. And there are many more issues. But I hope that all of this has helped to point out just how important the courts are in everyday lives of North Carolinians, and that now you can see why it's important for everyone to weigh in these important races. As I mentioned earlier, there's some materials on education about judicial elections and evaluation of judicial candidates on the website of the National Association of Women Judges. And the website is IVP for Informed Voter Project .nawj.org. And there are materials on there that are available to the public. So I would commend that to you if you want more additional information. And with that, I think we're done with the questions, and I'm going to hand it back to Robert Crane to wrap up the afternoon. Thank you so much.
Thank you. And thanks to all three of you. We, the original members of the North Carolina team, that is Sylvia, Mike, and I, would like to thank those who have come forward to help us organize our webinars on midterm elections. In particular, we'd like to thank Alice Bortson, without whom we could not have organized the first webinar. The participants in the first webinar, Representatives Deb Butler, Craig Meyer, Ashton Wheeler-Clemens, and Susan Fisher. Tim Warmoth, who joined us after the first webinar and was key to today's webinar on the North Carolina Supreme Court, and to our next one, which is currently in the planning stage, on the United States Senate race. Tim also brought Liz Fuller with her contacts and ideas to our group. And thanks to Art Shankler for facilitating contact with Justice Hudson. Today's Supreme Court participants, Judge Lucy Inman, Justice Sam Ervin IV, and moderator Justice Robin Hudson, also for helping give us all a better understanding of the North Carolina Supreme Court decision-making process. And finally, we owe a great debt of gratitude to Jennifer Von Estorth and to Carol Moore for their indispensable aid with communication and conferencing for Democrats abroad, enabling North Carolinians Abroad, our team, the North Carolinians Abroad team, to present these webinars. So thanks to you all. And now I'll turn it back over to Jennifer.
All right. Thanks so much, Robert. We're actually going to hear a short message, excuse me, from our Democrats Abroad Vice Chair, Art Shankler, who helped to make this possible.
Hi, thanks, Jennifer and Robert. I just want to say on behalf of Democrats Abroad, thank you to our participants. You guys were wonderful, and thanks to the North Carolina State team for putting this together. I should mention that I went to high school with Justice Hudson's husband, and I think I can now agree with Victor. He definitely married up. So good to hear from you, Justice Ervin. I kind of want to call you Senator Ervin. So I'm of that age. So but I was a utility banker, so I am sympathetic to your thoughts on the subject. And Judge Inman, I think if Justice Hudson has to leave, I think can be no better replacement. And I think as Justice Hudson said, this event emphasizes the importance of the court races for the court in those states where there are elections, as well as all state and local races. And this is something we will certainly be emphasizing to voters, our voters from overseas. North Carolina is a lucky state that all overseas voters can vote in all races. So that's important. And just one more thing, I don't want to be too partisan here, but I will be seeing North Carolina State Democratic Party Chair Bobby Richardson and the Vice Chair Floyd McKissick at a meeting in Seattle in a couple of weeks. And I will certainly mention this event and how thrilled, devoted we are to work with the Democratic Party in North Carolina to get out every overseas vote for every race up and down the ballot. With that, I'll turn it back to Jennifer. Thank you again. Cheers.
Thanks so much, Art. Thanks to everyone who joined us on the call today. Every time we hear from candidates on the ground, we are inspired and energized, and it really helps us, even though we are thousands of miles away, to keep up this work of getting out the overseas vote. We are so grateful for all of the tremendous work that you are doing on the ground in North Carolina, and we will keep up the fight on our end to turn out voters. On that note, please remember that all U.S. citizens abroad can register to vote and request a ballot North Carolinians should use the overseas voting portal. It's only takes a couple of minutes and you'll have your ballot within a day. If you've already received yours, please send it back. You can upload it to the portal again, and it must be uploaded by May 17th. In closing, I'd like to give a big shout out to all of our great volunteers, both on camera and behind the scenes. And thank you again to our participants for taking time to listen in and make an informed decision about the races on the ballot this year. We'll be sending out a link to the recording in the coming days. Please keep in mind that Democrats Abroad is an all volunteer run and funded organization. Your support goes a long way. A donation of $10 can help us reach at least 20 North Carolina overseas voters. We also hope you'll consider stepping up as a volunteer. No one else is out here doing the work of reaching overseas voters, and we need your help to make sure North Carolinians living abroad participate in this crucial election. You can join our Slack channel to get involved. Please also follow us on social media in the North Carolinians Abroad Facebook group and States Abroad on Twitter. We'll end the recording now and open it up for questions and discussion. Thank you for joining us, and don't forget to vote and help turn North Carolina blue in 2022.